Pam Bondi just cracked this case wide open. $127 million, 14 separate contracts, 3 shell companies per court filing submitted Thursday. She came prepared with hard evidence. I've been digging into this since yesterday. 4 full hours, 2 complete passes. The transcript runs 214 pages by itself. Here's what the news headlines are leaving out. Bondi, Trump's former choice for Attorney General, his staunch defender, his loyal ally, stepped into that courtroom Thursday morning, and by 4 p.m., she had turned over virtually everything to prosecutors. Wire transfers, executed agreements, time-stamped messages. This isn't a rumor. This isn't guesswork. This is sworn on-the-record testimony given under oath. You've seen the headline screaming, "Bondi testifies." Here's what actually went down inside that courtroom. Quick background: Pam Bondi, ex-Florida Attorney General. Trump tapped her for U.S. Attorney General late 2024. She was confirmed early 2025. For months, she served as the protective wall. Every probe, every subpoena, Bondi was the barrier. Then the Southern District of New York began tugging at loose ends: real estate transactions, overseas payments, questionable LLCs. Somewhere between January and last month, Bondi changed sides. Timeline in brief: a few weeks back, federal investigators sent subpoenas to 3 Delaware-registered holding companies. Soon afterward, Bondi's personal lawyer met with prosecutors on 2 occasions. Then Thursday, in courtroom 14B, Bondi appeared. Not as a target, but as a cooperating witness. Her immunity agreement had been signed the previous Monday. That's the context. What sets this apart from every other Trump legal chapter? Bondi was on the inside. She wasn't an outsider observing. She wasn't theorizing. She attended the meetings. She saw the paperwork. She heard the discussions. And according to the transcript, she recalls it all in detail. Now the evidence itself. First filing dropped Friday. I pulled page 34. It states, direct quote, "The witness confirmed direct knowledge of 3 separate agreements executed between January 2025 and August 2025, each involving payments routed through intermediary entities." That isn't commentary. That's the official filing. Translation: Bondi personally observed money moving and knows its destination. But this part stopped me cold. Page 89, different section, paragraph 47. Bondi testified she personally examined wire transfer receipts totaling $18.2 million sent to a Nevada holding company that maintained 0 employees, 0 office space, and no discernible business activity. I checked Nevada corporate filings. That entity was created 6 days before the initial payment arrived and was dissolved 11 days after the final one cleared. Put it together. This wasn't careless. This was deliberate design. Honestly, on the first read, I thought I'd misread it. Page 1 and 12, Exhibit F. Bondi turned over 47 emails exchanged between herself and 3 members of Trump's close circle, all sent during a 2-week window last spring. Subject lines included verbatim from the transcript, ripus arrangement, and offshore structure urgent. Read that twice. The former U.S. Attorney General handed prosecutors emails discussing offshore setups, sent while she was still serving in office. I read the whole thing twice. The pattern is unmistakable. Funds flowed through Delaware LLCs with almost no supporting documentation. Contracts were executed by stand-ins rather than principals. Conversations moved to encrypted apps whenever sensitive subjects arose. Every piece is documented, time-stamped, and matched against banking records prosecutors already possessed. Now the part almost no one is highlighting. Page 147, tucked in the appendix. Bondi described a February 2025 Mar-a-Lago meeting. 8 people present. Direct quote from her testimony. I was instructed not to document the conversation. I was told this explicitly. Yet she documented it anyway. Personal notes she kept at home, which she provided to prosecutors last month. Those notes mention a $340 million development project tied to a foreign sovereign wealth fund. The arrangement was deliberately built to evade CFIUS review. CFIUS, Satire Committee on Foreign Investment in the United States. It screens transactions that might affect national security. The deal was engineered to remain below their radar. Her notes contain the line, "They know the threshold, stay under." Immediate fallout, 3 fresh subpoenas issued Friday afternoon. 2 ex-White House staffers and 1 current member of Trump's legal team. The Nevada LLC is now federally investigated, and court records show prosecutors demanded banking records from 4 international banks, including 1 in the Cayman Islands, within 72 hours of her testimony. That kind of speed is rare. That covers only the first filing. There's more coming. If this kind of walkthrough helps, subscribe. I'm tracking this daily now. Filings are arriving faster than media can process them. I'll keep breaking them down. To be fair, the other side has arguments worth hearing. A few actually carry weight. Trump's legal team frames this as politically motivated prosecution disguised as law enforcement. First, Bondi received immunity. She isn't an impartial witness. She negotiated a deal to protect herself. That shifts her incentives. Everything she says advances her own legal position. Second, none of these transactions have been proven unlawful yet. Complex? Absolutely. Offshore? Yes. But complexity isn't automatically a crime, and offshore structures aren't inherently fraudulent. Trump's lead attorney, who's represented him since 2019, said Thursday night, "This is a disgruntled former employee seeking leniency by telling prosecutors what they want to hear." I don't buy every piece of that, but it isn't baseless. Immunity means she had strong motivation to produce something valuable. Prosecutors don't grant it lightly. That pressure can lead to exaggeration. The LLCs, Delaware, Nevada, are perfectly legal vehicles used by thousands of legitimate companies every year. Simply forming an LLC proves nothing improper. Even legal commentators who don't support Trump acknowledge this. A former federal judge now teaching at Georgetown Law said Friday, "The complexity of these transactions doesn't prove intent. You need more than structure." I'm not here to declare a winner. Prosecutors view Bondi's testimony as catastrophic. It demonstrates knowledge, planning, and deliberate concealment. Defense views it as purchased testimony from a witness desperate to avoid her own charges. Both interpretations can coexist. That's why this feels so tangled. What I keep returning to? Bondi didn't merely speak. She delivered documents, physical records, emails, personal notes, wire confirmations. You can challenge her motives. You can question her reliability, but the documents themselves exist. The emails are real. The transfers happened. The dates align. If this were only her verbal account, reasonable doubt would be everywhere. It isn't only her word. Conservative commentators are already calling it betrayal. Bondi turned against the president who elevated her. That narrative is taking hold in right-leaning outlets, and it resonates. Loyalty carries weight in politics. To many who trusted her, Bondi was genuine, or at least convincingly loyal. Her switch feels like a personal wound. One ex-Trump campaign aide posted Friday night, "She was family. This is unforgivable." That feeling is authentic. Don't brush it aside. What the documents actually reveal, and prosecutors now fully possess, is a detailed paper trail handed over by someone who was physically present in the room. Whether this represents justice or retaliation depends on your perspective. The evidence, though, is what we can examine. This didn't appear out of thin air. Backstory in brief. Roughly a year ago, early cracks appeared. Bondi clashed with Trump's inner circle over how to respond to SDNY subpoenas. She favored cooperation. They preferred stalling. Months later, she was quietly excluded from important meetings. Title remained, access didn't. Around last year's holidays, her name appeared in a separate investigation, not as primary target, but uncomfortably close. Someone told Politico on record, she saw the walls closing in and made her choice. Pattern we've seen repeatedly in this orbit. Loyalty is prized until it becomes legally risky. Legal risk is managed one person at a time, never as a group. When heat intensifies, self-preservation kicks in. Bondi observed Michael Cohen, Rudy Giuliani. What happens when loyalty outlasts legal safety? She chose differently. Every insider who has flipped followed the same math. Difference here, Bondi possessed access few others had. Cabinet-level clearance, classified briefings, conversations that arguably shouldn't have occurred in front of a potential witness. Prosecutors now hold all of it. People wonder, why keep notes? Why preserve emails? Perhaps as protection, perhaps instinct. Perhaps she always sensed this moment might arrive. Either way, Thursday changed everything. Before Thursday, it was conjecture. Now it's sworn testimony. If you're following the trail, hit like. The algorithm decides visibility. A quick like tells YouTube this kind of detailed breakdown deserves wider reach. Takes 1 second, helps significantly. Thursday, 2:47 p.m. Eastern. Under direct questioning, Bondi was asked about a particular meeting. Oval Office, February 14th, 2025. She paused, glanced at her lawyer, then stated, "I was present when the president discussed structuring the Doha Agreement to avoid congressional notification requirements." Courtroom went quiet. Immediate aftermath. Trump's defense counsel requested a sidebar. Prosecutors asked for a 15-minute break. 3 journalists rushed out to file. 23 minutes later, testimony continued. Bondi methodically walked through details. The agreement concerned a $340 million development in Qatar, American partners, foreign funding, and, per Bondi, explicit direction to keep it below mandatory reporting thresholds. What almost everyone overlooked. While press fixated on the dollar figure, Bondi identified people, 8 individuals, including current and former officials and 1 sitting member of Congress. The transcript was partly sealed within the hour, but reporters captured the essentials first. Friday morning, one of those named individuals publicly retained white-collar counsel in D.C. and released a denial of wrongdoing, unsolicited. That's noteworthy. The congressman's office issued no comment, directing all inquiries to legal counsel. Also revealing, judge scheduled an emergency status conference for Tuesday. Timeline accelerated deliberately. Docket shows prosecutors requested expedited discovery Friday afternoon. It was granted within hours. Something in that testimony prompted rapid movement. Here's where it turns compelling. The sealed section of Thursday's transcript, we don't know its contents, but we know prosecutors requested the seal. They're shielding something, someone, or laying groundwork. Tuesday brings more clarity. Leave your prediction in the comments. What do you think is in the sealed portion? Who else gets identified? I'll return to this section after Tuesday's hearing. Let's see who was right. Expert reactions. Former SDNY Assistant U.S. Attorney, 17 years there. When a cabinet-level official flips and delivers contemporaneous records, that isn't a stumble, that's seismic. In plain terms, this is uncommon. When it occurs, cases gain velocity. Another, criminal defense lawyer, 22 years federal practice. The immunity deal reveals everything. Prosecutors don't grant immunity unless the value received exceeds what they surrender. They gave her a pass. That means she delivered something larger than her own potential liability. Notably, even some former Trump legal advisors concede gravity. One ex-White House counsel attorney told CNN Friday, "The documentation is the real issue. You can discredit a witness. You can't discredit a wire transfer receipt." When both sides converge on a point, take note. Legal analysts are reaching consensus. Bondi's testimony by itself won't secure an indictment, but it unlocks doors. The records she supplied can be independently confirmed. That's the danger. The sealed portion signals additional material ahead. Prosecutors don't seal lightly. NYU constitutional law professor wrote last night, "We are witnessing a live test of whether anyone is genuinely above the law. The outcome remains uncertain." Former Obama-era DOJ official now at Brookings. This combines elements we haven't seen together before. Cooperating cabinet member, active concealment claims, foreign funds, congressional involvement. Each piece serious on its own. Together, she left the sentence unfinished. She didn't need to finish it. The legal process is advancing. The question isn't whether exposure exists, it's how broad. If this explanation clarifies what's really unfolding, hit like. I'm not chasing viral clips. I'm reading primary documents. That like signals YouTube this content has value. Thanks. Why care? Straight talk. How this touches regular people. Money. If you hold investments in U.S. markets, watch closely. Political turbulence moves portfolios. Not partisan. Simple math. Friday, defense contractor stocks fell 2.3% after the Qatar link emerged. Markets dislike uncertainty tied to foreign transactions. Your 401k likely includes companies now urgently reviewing compliance. Not financial advice, just what the market is already reflecting. Precedent. This rewrites rules around executive privilege. If a sitting attorney general can be compelled to testify against a former president with supporting documents, the next headline mentioning executive privilege will cite this case. Simple analogy. Imagine your CEO instructs you not to record a meeting. You record it anyway. Years later, you provide those notes to investigators. That just occurred at the highest level of government. Future administrations and officials will factor this into every decision. Who's immediately impacted? 23 individuals referenced in unsealed portions of Bondi's testimony. 8 named explicitly. 15 identified by role or description. Prosecutors know identities. Public doesn't yet. Federal employees in connected agencies received legal hold notices. Monday, preserve everything. Delete nothing. The uncomfortable reality few voice. If prosecutors are correct and these deals were structured to dodge oversight routed through shells with foreign funds, then policy choices, appointments, and regulatory decisions during Trump's second term may have been shaped by undisclosed financial arrangements. If you voted in 2024, you're connected to this. Not your fault, but affected. If you pay taxes, you're connected. Public resources, your resources, were directed based on priorities now under scrutiny, not fear-mongering. That's what the documents imply. What informed people are doing right now: monitoring investment exposure in politically sensitive industries, tracking Tuesday's hearing for names and scale, asking advisors, what's my firm's connection here? Information protects. This isn't theoretical. Funds moved, choices were made, fallout is arriving, legal, political, financial, or some combination, depending on those sealed records. Larger view. The unspoken reality: Bondi wasn't peripheral. She was core, loyalist, defender, true insider. If she turned, who else is quietly reevaluating? That mental math is happening across D.C. offices, law firms, private conversations. Thursday, the first piece fell. We're watching whether others follow. Trump's response? Honestly, it backfired. Thursday night on Truth Social, 11 posts in 3 hours, labeled Bondi unstable, desperate, an embarrassment to Florida. First post quote, "She was never smart enough to understand what she saw, confused woman." Result, 4.7 million views in 12 hours. Friday morning, Bondi's lawyer requested extra security. Republican leadership reaction, uneven. Some immediately defended Trump, deep state tactic. Others stayed conspicuously silent. One senior Senate Republican, unnamed, described as close to leadership, told Axios Friday, "We need to see what's in the sealed documents before anyone should be making declarations." That isn't defense. That's creating distance. Trump's legal team issued a formal statement Saturday morning. Ms. Bondi's testimony is the product of prosecutorial coercion and personal desperation. We will address every allegation through proper legal channels. Saturday afternoon, they filed a motion to exclude parts of her testimony, asserting attorney-client privilege over several discussions. Prosecutors countered, Bondi wasn't serving as Trump's attorney during those exchanges. She was a participant and witness to them. That dispute unfolds Tuesday. Tension is rising, not easing. Pattern. Every defense move prompts a prosecution filing. Every social media outburst gets referenced in court documents as potential intimidation evidence. They're not helping their position. Still unknown. Contents of the sealed transcript. Bondi testified 4 hours. Only 90 minutes public. Remaining 2.5 hours sealed pending investigation. Substantial undisclosed testimony. Identity of the sitting Congressman Bondi named, current member of Congress. We don't know who. Their office does and isn't commenting. Full foreign dimension. Qatar, Cayman Islands, Cyprus mentioned. Complete extent of overseas involvement still unclear. Key dates: Tuesday, March 10th. Status conference before Judge Mercer. Privilege arguments heard. Prosecutors have signaled possible additional indictments this month. Congressman's counsel reportedly negotiating, details unknown. Thursday, March 12th, grand jury reconvenes. New evidence expected. March 17th, tentative date for next witness testimony. Identity not public. Still hidden. Full scope of Cayman banking records request. Any cooperation deals with other witnesses. Contents of the sealed 2.5 hours. Clock is ticking. Between now and Tuesday, both sides are drafting briefs, refining media strategy, coordinating witnesses. Tuesday's outcome heavily influences March. If privilege holds, slower pace, prolonged legal battles, possibly months more. If privilege fails, acceleration, additional names, further testimony, potential indictments before April. We're in the tense waiting period. Current snapshot, Saturday, March 7th, 2026. Bondi completed initial testimony, may be recalled. Partial transcript public, significant portions sealed. 8 individuals named, status unclear for most. 1 congressman identified, name sealed. Trump's team filed privilege motion this morning. Prosecutors demanded expedited discovery from 4 foreign financial institutions. Tuesday, March 10th, status conference, privilege fight. Thursday, March 12th, grand jury returns. March 17th, possible next witness, Pam Bondi. Cooperating witness, immunity granted, testimony entered. Donald Trump defending, counterattacking, now legally vulnerable in ways unimaginable a week ago. Surface narrative. Loyal ally turns, brings proof. Deeper reality. Bondi didn't switch spontaneously. Something, her own exposure, prosecutorial pressure, perhaps more, pushed her. The sealed testimony is pivotal. What else was said? Who else appears? What arrangements are detailed? I'll follow Tuesday's hearing closely. The privilege battle reveals how both sides assess what's ahead. This story continues. Fast moving, promise. When filings land, I'll read them. When transcripts emerge, I'll explain them. When experts speak, I'll filter noise from substance. This isn't clickbait. It's trying to grasp what's really occurring. Subscribe for the complete view beyond headlines. The legal process has momentum. Bondi's testimony cracked the door. What comes through next? We'll learn Tuesday. I'll be here. Talk soon.